Hey guys, Dr. Scott here. Want to welcome you to week 2 of criminal procedure for the summer session. Uh, I'm going to cover chapters 4, 5, and 6 during this video lecture, and I'm going to give you an overview of what's in the chapters and give you some real-world perspective from a law enforcement point of view of how we interpret some of the concepts in chapters 4, 5, and 6. First of all, I'd like to say welcome to the class. I've enjoyed meeting many of you guys on the internet through the Blackboard and your introductions, like I said in my post. Some of you guys I've had before, so it's good to see you guys back in class. The quiz will post later tonight once I get it written. The one I had was outdated, and some of the questions were no longer in the current text, so I had to throw it out, and I didn't catch that until I got to Nacogdoches this week, and that's where I'm currently talking to you from, is my hotel room here in Nacogdoches. I'm down here training some officers for the next 3 days on sexual assault, family violence investigations. It's something they need for part of their licensure before August 31st. Anyways, starting with Chapter 4, we're discussing the exclusionary rule. And I put a video in here that kind of explains what the exclusionary rule is and how it works. When we're talking about the exclusionary rule, what we're trying to do is basically deter police from misconduct. And what we mean is that evidence that's seized illegally, meaning that we didn't have a legal right to go into the place of business or on the property and take it, and it wasn't in plain view, and we weren't going to find it inevitably, meaning that if we were there for another reason and stumbled across it in good faith and found it, means that we can't use it in court. Okay, like the stop and frisk that New York police officers used to do, it was deemed admissible to a certain point, but a lot of it, when it was first written, basically dealt with the fact that you just can't arbitrarily stop someone on the street, pat them down, if you find a weapon, arrest them for it. You have to have some kind of suspicion that they're up to something suspicious or doing something illegal, and that brought your attention onto them or that activity, and then you go from there. Now, the exclusionary rule now applies to a lot of things, okay? And we're talking about not just evidence we see like narcotics or stolen property. We're also getting into the realm of cyberspace. We're getting into emails, cell phones, text messaging, child pornography, and thumb drives, stuff like that. And now the law is having to basically be examined when we start talking about, did we find something on a thumb drive? Did I see something on your computer screen? And did that give me the legal right to go in and search your hard drive and take your computer and all that? So I'll talk about that in just a little bit. But what we're looking at now in terms of the exclusionary rule, I'm looking at things, I have an outline here, I'm making sure I don't miss anything, is how it works, all right? Determining what's not going to be admissible is going to be basically anything that's seized illegally, meaning that we didn't have a warrant, we needed to have a warrant, we didn't have valid consent, or we didn't have consent from the person who actually owns the property, like the home or the car or something like that. Now, what a term mentioned in this chapter is what we call fruit of the poisonous tree doctrine. And if you've been reading the chapter or you haven't had a chance to read it yet, that's a term where we're in there doing something legal. We have a legal right to be doing it, but we go about getting something or doing something in an illegal manner. Let me give you an example. Let's say I go to a call and there's a disturbance. And while I'm there, I look on the shelf and I happen to notice this guy's got a bunch of car stereos. Now, normal people wouldn't have 15 or 20 car stereos on a shelf inside someone's house. That would lead me to believe that they're possibly stolen. I asked the guy, let's say the owner's there, and I said, hey, what's the deal with all these car stereos? And I said, well, the guy says, well, nothing. I'm not going to talk to you. If you want to, ask me about those car stereos, I'm going to have to talk to my lawyer first, or you have to get a warrant. Okay. Well, let's just say curiosity gets the better of me, and I'm looking at the car stereos, and they're all facing me, which means the serial numbers are on the side and on the back, and out of morbid curiosity, I manipulate and move the car stereo, and I get the serial number, or I pick one up and take one out, even though when I've been told by the owner of the house that I don't have permission to do it. And I get the serial number, and I get on my radio, and I run the serial number, and sure enough, it comes back stolen. And I seize it, and I arrest them for possession of stolen property. Well, the question comes to bear now, is this going to be admissible in court? The arrest and the case and the way I went about getting the serial numbers off the stereo. The answer is no. And this goes back to the metaphor of the fruits of the poisonous tree, meaning that anything I did illegally, all right, basically from the ground up with this tree, the tree's a metaphor, that anything I get, the fruit being other evidence and stuff like that, is basically going to be poisonous. That means because I went illegally to look at those serial numbers, all those stereos that are potentially stolen, I can no longer get in court. I can't charge them with it. It won't go to court. The case is over with. And that's just a very simple explanation as to how the fruits of the poisonous tree doctrine works. Now, when we talk about exceptions to the rule, now you got to remember we're dealing with law here, and with every law we have, every rule, there's going to be exceptions. All right. Now we know from the text and what I've told you here in the last few minutes that we can't seize things illegally, but if we happen to get items that we didn't have time to get a warrant for, or we would have found inevitably because we happen to be at the right place at the right time, there's going to be exceptions, and there's 4 exceptions in this chapter the book talks about. Number 1 is the good faith exception and its variations. Let's say I go do a check welfare of someone's health. I go assist the fire department or EMS or something, and we're checking someone's welfare, and the neighbors have a strong smell of something coming from a house. And when we get there, we're thinking maybe it's a dead body or something's going on there. And we make entry into the house. We've knocked on the door. We can't get in. And we have a lawful purpose to check the welfare for the life of somebody. As we knock on the door and no one answers and I make entry, I find someone who's passed out. Let's say they're not dead. They're just, they're just asleep or whatever. And as I walk into the house to check on the welfare of them, I see there's a meth lab in the kitchen. They constructed a meth lab. So I back out because meth labs are inherently dangerous. But I basically get the guy out. We get him in the ambulance. We revive him, and I charge him. And we basically charge him with production of methamphetamines. He's going to go to court. He's going to appeal, saying the search was unlawful. Well, the judge will look at this case on its face and say, look, Sergeant Scott was there doing a check welfare. He had to go through the kitchen to get to you, and from his training and experience, he walked in the middle of a meth lab. All right, that would be okay. All right, I acted in good faith. I wasn't looking for a meth lab. I was looking to check the welfare of a human being, and I just stumbled across it. That would fall under the good faith category. Inevitable discovery exceptions. Let's say that we're chasing, or let's just say, I don't know, I'm on patrol one day, and as I make a traffic stop, and the guy's got several bags of marijuana, in the car. Okay, I stop it. I make a traffic stop. I smell it, and as I smell the marijuana, I'm pretty sure I know what it smells like from training and experience. I've been exposed to it on the job, not using it for the record, in case you are wondering. But I get the guy out. I check him for warrants. He's got a warrant. Okay, no problem. Well, as I'm searching the car for drugs and marijuana, I see a pistol at the bottom underneath the floor, underneath the seat of the front seat. He had a gun on him. And basically, I run the serial numbers, the gun's stolen, he's a felon, he has a stolen weapon, and he's a felon in possession of a firearm, which are 2 laws in Texas you can't do. I would charge him with that because it's on him and it's in his custody. And he would appeal saying, oh, no, you didn't have a right to look for a gun, you were looking for drugs. Well, inevitably, me searching the car or doing an inventory of the car, which is inventory and searches are 2 different things, which we'll get into later in the chapter or in this book, I would have found it anyways. So let's say I'm running a search warrant. Another one, I'm searching for child porn or something like that. And the warrant says I can look in any place in the house for child porn or child pics, media pics, thumb drives, flash drives, whatever could be held. And as I'm searching the house, I come across narcotics. The guy's got marijuana, cocaine, or whatever, Oxycontin. And as I'm searching for my warrant, I found it. Okay, I would be okay charging him with that because I acted in good faith and it was inevitable discovery. The other ones they talk about is the purge taint exception and the independent source exception. The independent source would be, for example, a confidential informant or a neutral third party told me that there's a crime being committed or a person committed a crime, and this person I believe to be credible. I acted on the information and then made an arrest or found whatever it is I was looking for. Okay, so there are exceptions to every rule. Now, when the rule does not apply, is in violations of the knock and announce rule, meaning that if I'm going to serve a search warrant, in most circumstances I have to knock and announce, and then hit the door if we're going to go in, like on a SWAT raid or something like that. All right. If I think there's drugs in there and I just do a knock and announce and I go in and I don't arrest anyone, I'm just there for the drugs, and then I'm trying to build a case after the fact, it's not going to work. In searches by private persons, let's say I get a tip that, like, say I'm in a hotel this week, and we have reason to believe that there's someone selling drugs or there's drugs in a hotel room. Well, what I can't do is say the person who told me thinks there's drugs or we believe there's drugs in there. And once we go inside to the hotel, I can go into the lobby, I can go to the hallway. But what I can't do is go into the room. The guy's not giving me consent. He's not answering the door. Well, here comes the girl that, the guy that cleans the rooms, and I say, hey, can you clean this room first? And when you go in there, tell me if you see anything illegal. All right. What's the problem there? Well, the problem there is that I am basically ordering or administering my power and authority, giving a third person my authority to go in there and look for something illegal, come out and either bring it to me or tell me about it. That person is in essence acting as an agent under my direction, and the courts say that's no bueno, that's no go there either. In a grand jury investigations and sentencing, they can't go on fishing expeditions or go beyond the scope of the case that's brought in front of them. When the arrest based on probable cause violates state law, meaning that I am arresting someone and it's a misdemeanor that didn't occur in my presence, it's already happened, and I need to go back and either get a warrant or file the case, and I just kind of skip a few steps and arrest someone simply because they pissed me off, or we think they're involved in something more. We try to do something more than we should with our authority. That's not going to happen either. In non-criminal proceedings, I can't search to say it's a civil issue. And let's say a landlord's kicking a tenant out and they want the police to stand by. I can't go into that apartment or that house and search it for narcotics or stolen property until that person's vacated or the owner or whoever has control custody of the house walks out and basically says, okay, everything in there is not mine. Go in there and get it, or they bring it out to the street. So there's things we can and can't do. And the chapter does a great way of explaining this. Now, at the end of the chapter, you guys will notice that there's arguments for the rule and arguments against the rule. Read that, all right? Because basically you'll see both sides of thinking, the conservative and liberal side, of why we have the exclusionary rule. And then there's going to be a discussion, and it's only like a page, alternatives to the rule, and then the future of the rule, where it's going to go in the future in 2015 and with cyberspace and invasions of privacy and all that other stuff. Now we move on to Chapter 5. In Chapter 5, I again gave you a video for this also that discussed stop and frisk and station house detentions. Now the big case in this that I want you guys to focus on is Terry versus Ohio. In the last chapter, Chapter 4, there's another one called Mapp versus Ohio. Those are two separate cases dealing with two different things. Mapp v. Ohio and Terry v. Ohio, very important cases. Please study those and get to know those intimately for the exam and for your career in law enforcement if you're going to go that way. The stop and frisk, basically, we have to have a reason where we see someone suspicious to stop and detain them. Now, the courts now say, under Terry versus Ohio, if I have reason to believe that this person might be armed or engaged in a criminal action where weapons might be a situation, by law, I can pat the outer clothing to see if there's a bulge or something that would basically be a weapon. That could be a firearm, a pistol, a rifle, could be a knife, anything that could inflict serious bodily injury or death to me or another officer. I can pat the outer clothing. It's a pat down. It's not a search. Now, the difference between a pat down and a search is simply this. I pat you on the outside, okay? I use the ridge of my hand for ladies, or I just pat you down around the waistband, over the stomach, behind the back, up and down the leg, up to the crotch area, around the ankles, especially those of you girls and guys that wear boots. I can squeeze the boots, and if I feel something, I can ask you what it is. If I think it's a weapon, I can go in there and take it out for my safety and for yours. What I cannot do is go into your pockets, whether you're wearing a coat, a shirt, or jeans, or pants, and if I feel something that's like, plastic or squishy or something like that, that might be narcotics, that's not what this is about. This is the patting the outer clothing for weapons, and that's pretty much all about Terry v. Ohio. Now, there's two separate acts when we do this, all right? There's the stop and the frisk. I can legally stop you and ask you for your identification if I can articulate that you might be connected or part of a crime or an ongoing investigation that I'm looking for, all right? By law, you need to give me your name and identification for investigative purposes. Now, I can't just do this arbitrarily because I'm working a high crime neighborhood and I start stopping everyone at random. That won't work. The frisk is the pat down, all right? If I have a vague description of someone that was just involved in an armed robbery, for example, and I stop you and you match the general description of who I'm looking for, because let's be honest, Eyewitness testimony is horrible. It's wrong most of the time. But I see you running or coming from the general vicinity of a crime that involved a weapon. I can stop you, detain you, get your information, and pat you down for weapons. Now, when you guys read this, there's other types of stops and frisks. There's applications go to motor vehicles, weapons in a car, and applications to a residence. When I'm going to stop a car, the law basically says that I don't have to get a warrant if I have a legal reason to stop the car and I see something in plain view or one of my senses smells, sees, or detects an illegal substance, or I see a weapon or I see something stolen in plain view. I can get you out of the car. I can search the vehicle. Now the trick on this is with vehicle searches, I can only search the area that is in your immediate control. That would be the glove box, under the passenger seat, under the driver's seat, behind the passenger seat, behind the driver's seat. All right, that's going to prohibit me from going into the trunk, looking in the engine, going to the gas tank, and all that other stuff, unless I have reason or the owner or the actor's consent, who's got care, custody, and control of the vehicle, to do that. So be sure to read that. Weapons in the car, it's not illegal if you're over 21, not a felon and committing a crime, to have a weapon in a car. All right? But I can't ask, by law, you're supposed to tell me about it, especially if you have a concealed handgun license. If I get in there and I'm searching the car and I see a weapon, all right, I have all kinds of avenues. I can say, is this yours? And if you're saying, look, man, I'm just borrowing the car, I'm not the owner, I had no idea that was in there, and I have a sense that you're genuinely telling me the truth, okay, fine. If it was used in the commission of a crime or I'm stopping you because of a crime, that's a different story. If I run the gun serial numbers and it comes back stolen, that's going to be a different story. So there's all kinds of different avenues with that. Application to arrest a residence, when we stop and frisk a residence, like say a hotel room or house or an apartment, we can basically get there and we smell marijuana and we see it on, say, like a coffee table in a hotel room. We can stop and frisk everyone in there, hold them for possession or smoking marijuana or whatever, or cocaine or pills. But once I'm in that room, I can only get the things that are in plain view. But let's say if I think there's going to be stuff in the drawers or under the bed or anything that I'm going to have to manipulate, like open a closet and all that, that I'm going to have to physically look into, the rule of thumb is if I can't get consent from the owner or the occupant of that residence or dwelling, I stop, hold what I got, and go get a search warrant. And then that'll give me carte blanche to do what I need to do in terms of getting the stuff legally, which is what we want. So review Mapp versus Ohio, review Terry versus Ohio for chapters 4 and 5. Now, when we talk about arrest and use of force, man, this is a great week to do it because we're watching what went down in McKinney, Texas the other night. And depending on what your opinion is of that officer, all right, I've got my own opinions and I'm not going to share them right now because you're going to think I'm biased because I'm a cop. But long story short, watch the whole video, all right? You had a guy who went to a disturbance with several hundred people by himself. They weren't complying. And at one point, he thought the two guys that you see on the video were going behind him, were going for his weapon or something like that, and that's why he drew his weapon. All right. That being said, if I can, I'll put the whole video up and let you guys make your own decisions. The broad picture of arrest searches of persons. Now, when we talk about arrest, we're dealing with Fourth Amendment rights, okay? So go in that chapter, read the Fourth Amendment, and get an idea of, the right to illegal searches, the right to, privacy, and get used to that, okay? It has to, without a warrant, and you don't have consent, you're gonna have a bad search. The top 10 intrusive searches and seizures of a person can be that of the person. It can be medical. It can be a needle when you're puncturing the skin, getting blood out for, say, a drug test or alcohol test. There's all kinds of different things that go on with it. All right, body cavity searches, for example, other things like that. So what is arrest? Arrest is effectively you are stopping a person who you believe or you have knowledge of that has committed a crime, and you are effectively you are stopping all their physical liberties, all right, for the sake of justice. You're putting them under arrest, you're stopping them from what they're doing, and you're bringing them to the nearest magistrate to be read their charges, what they've allegedly done. Now, you got to remember, we got to keep in mind that they are proven they're innocent until proven guilty. Even if you've got first knowledge that they did it, it's up for a court to decide. We have knowledge right now to make an arrest, all right, to basically take them to jail or take them to the magistrate. Now, there's 4 elements to an arrest, okay? Search and detention, I can stop them long enough to search them for any weapons or contraband, stuff they shouldn't have, and I take it. put the handcuffs on him, put him in the back of my car, transport him to the nearest jail. All right. I have to show that I have an intention to arrest. Now, sometimes I'll get there, I'll start talking to you, then I run your name, you come back with a city warrant or a traffic warrant or something like that, and I'll place you under arrest. I see something, or you admit to me committing a crime or something like that, I'll place you under arrest. The arrest authority, my authority to arrest you comes from the state of Texas. I'm a police officer acting in good faith and under the color of law, meaning that I've identified myself as a police officer and I'm acting, within the laws of this state of my jurisdiction to place you under arrest and take you before a magistrate. Citizens can also make an arrest. If they see something and it's illegal, they can detain a fellow citizen either at the request of law enforcement or of their own volition, and then summon police to basically look into the investigation and make the arrest. Let's see. Understanding by the arrestee has to understand that they've been placed under arrest. You have to notify them of the charges you're charging them with. They have to understand that you're a police officer and go from there. So there's 4 things to an arrest. Now, when you stop and arrest someone, also, the courts are looking at the length of the detention and the arrest. All right. If I detain you, say, on a traffic stop, and I think there's narcotics in the car, all right, question comes to bear is, and you don't give me consent to search, and I call for a drug dog to walk around your car and hopefully get a hit on the car, meaning the dog will smell something and start scratching. All right, I have to make sure I can get that dog there within 30 minutes, or I'm not saying 30 minutes or less, like a pizza. But what I'm thinking is it has to be within a reasonable time frame. I can't spend 4 or 5 hours on the side of the road waiting for a dog to get out there, and that's just it has to be reasonable. And the courts won't give us an exact time, but they have to give us a reasonable amount of time. Now, arrest with a warrant. When is a warrant needed? How do we get a warrant? The contents of a warrant. Who provides the warrant? The time of arrest. And, how does a warrant expire? Normally, a warrant comes at the bequest of a justice of the peace, judge, or magistrate. All right, and it's ordering or commanding an officer to find this person and bring this person before the court as soon as possible. Now, when I have an arrest warrant, usually it's good until the arrest is made. A judge will look at it. It'll be based on probable cause that we believe this person at this date and time committed a particular offense against a person, property, or something like that, and we'll make an arrest from there. Once the arrest warrant's been made, we brought them to the judge. A copy of the warrant goes to the judge with your probable cause affidavit, book-in sheet from the jail. Someone knocking on my door. Sorry, I thought someone was at my door. And they'll go from there. Now, arrest without a warrant, there are times I can make an arrest on site. If I see that a felony's been committed in my offense, a judge sees an offense and orders me to make an arrest, I can do it right then and there. Some misdemeanors like family violence, violation of a protective order, or theft, whether it occurred in my presence or not, but I go and investigate after the fact, I can make an arrest there also. Sometimes in crimes committed in public places like city ordinances, like you find a guy that's intoxicated to the degree that they're a danger to themselves or other people, we can make an arrest there also. If I see someone that might be urinating in public or creating some kind of what we call a nuisance law violation, or what we call a city ordinance violation, instead of writing them a ticket, we can do what we call in standardizing and take them to jail. Basically, we take them to jail, they post bond in lieu of being written a ticket. When exigent circumstances are present, meaning there's no time to get a warrant, and it's basically for my safety, the safety of other people, or for the suspect, mental health commitment, I can place them under arrest for mental health, take them to the nearest hospital and get them to do a psychiatric evaluation. Or a suicidal person, there's no time to get a warrant, I just got to act and put them in handcuffs. When I'm entering a home without a warrant, or when there's danger to a police officer, we can basically make an arrest. We get there and the guy starts fighting, or it's a shootout and we're trying to sift things out, or it's a drug call or something like that, or we hear family violence and there's no time to get a search warrant to bust in. We hear help, and they're screaming for their lives. We might kick the door down and go from there. What do we do after the arrest? Well, we take them to jail. Once they go to jail, typically they're strip searched. We do paperwork. We put them into the jail. We enter our report into the system. We take a case packet and we send it to the district attorney's office. While the suspect's in jail, depending on the level of offense, they might be able to make bond that night, or they have to wait till the next morning to when a judge will see them, and it'll be called an arraignment hearing, where a judge will read the charges presented by that arresting officer to the suspect and say, these are the charges. Do you plead guilty, not guilty, nolo contendere, meaning that I'm guilty but I don't want to talk about it, and then they'll set a bond or decide if they want bond at all, and they may have to sit it out. With motor vehicles, we will tow the vehicle off if we need to, if we can't find a responsible driver. But when we're doing basically after an arrest, let's say I stop you on a traffic stop, you got warrants, I can basically do one of two things. I can do an inventory of the vehicle, which means I inventory everything in the vehicle from the front of the car to the back of the car, and I do an inventory. If I happen to stumble across something illegal like weapons or drugs or something like that, well then from there I can basically seize that stuff and charge you with it because I found it in good faith. Use of handcuffs, arrestees' movements, and all that. Handcuffs are designed to basically keep that person protected and myself protected. All right, if you're detained and you can't move, I don't have to worry about you trying to escape, hurt yourself, hurt me, or anyone else. What we cannot do during an arrest is enter into third-party residences. All right, once I'm there and I have someone in custody, I cannot start jumping around house to house looking for other people without consent or without probable cause. I cannot conduct a warrantless protective sweep unless justified. Cannot invite the media to do ride-alongs. All right. A lot of police departments back in the day wanted to bring the media out. Hey, come see what the cops do. Well, the Supreme Court recently ruled that it's a violation of the person's Fourth Amendment rights if the media or a third party comes out on scenes who are not law enforcement and don't have a legal right to be there and start recording criminal activity or seeing things that the normal public wouldn't have access to see. So we got to be careful about that. Other issues that we're looking at, can the police detain a suspect while obtaining a search warrant? Yes and no. Like I said, the law is not that not the greatest in terms of interpretation. Can we detain them? Yes, if we can get them on another violation, or if we think that they're going to be a flight risk, or if it's a felony. Yes. If not, then we cut them loose. We'll look for what we're looking for, and then we will file charges. It's that simple. Can the police arrest for traffic violations or petty offenses? Yes, we can. We can do that. Are arrests of offenses not punishable by prison or jail time valid? Yes, they are. And are citizen arrests valid? Yes, depending on the circumstances. So read about those. Use of force during an arrest. What governs police use of force? Well, typically it's going to be the law and your policy. All right. Normally, we have what we used to call a continuum, but the continuum's kind of gone out of the way because every circumstance is going to be a little bit different. And what we're looking for in use of force is we can only use the amount of force necessary to stop and control a situation. Meaning that sometimes my presence alone in uniform would stop it. Telling someone to say, hey, stop, and they stop doing something, I might have to put what we call soft hand touch, meaning I gently touch someone or hold on to them. Hard hand might be a strike. It might be a push or takedown to the ground. If that doesn't work, I've got what we call impact weapons, which would be like a baton or the nunchucks or something like that, where we strike the person to get them to stop and comply. If that doesn't work, I'm sorry, before impact weapons, I'm jumping ahead. We might have our OC spray them into compliance to control them. We might have the taser. Then we would have an impact weapon. And then last but not least, we might go to a firearm. Meaning that when I get there, this person's got a gun or a deadly weapon, my level of force would be an appropriate response, which would be my firearm or an AR-15, depending on the circumstances. I go to a gunfight, I need to have a gun. I go to a knife fight, I want to have a gun. All right. If I got someone who's just acting crazy, but I can see their hands and they're not making any sense, and they start trying to attack me, I might pepper spray them, OC spray, or I might just hit them with the taser. And they'll drop, hopefully, and then we'll put them in handcuffs. As soon as we're done with the force and we get the desired result, we stop with the force. We back off. We don't just keep zapping them because we're bored and having fun. Once the taser's been deployed and it's worked, we get them on the ground. We go in, we form an arrest team. We put handcuffs on them. We call EMS. They take the prongs out, and we go from there. So familiarize yourself with the use of force. I will try to find the whole McKinney video and post that for you guys. Y'all can watch that if you haven't watched it already on YouTube. So with that, I'm going to briefly wrap up chapters 4, 5, and 6. I would look at some of the cases. Like I said, Terry v. Ohio, Matt versus Ohio are very important. Peyton versus New York for use of force is another good one. And I will get your quiz up later this evening. So you guys have a great week. As usual, all of you guys are doing a great job. Keep up the hard work. I know this is a fast-paced course, but we're going to get through it. So I will talk to you soon, and I will be making some more postings this evening. You'll have a great week, and I look forward to reading your posts on Blackboard. Take it easy.